you a chip, Mr. King.
May it please the court. My name is Miranda and I represent the state of Florida. I'd like to reserve 2 minutes for rebuttal, please. The trial court's order in this case, suppressing the statements of Mr. Garwacki and Ms. O'Connell, misapplies the law, reaches factual conclusions not supported by the record, and in some instances simply applies the wrong law. Now, the court did recognize the Ramirez factors in determining whether or not these two individuals were in custody. The problem is that although the court recognized those factors, for 3 of those 4 factors, the court relied heavily on this notion that the detectives circumvented the requirement of giving Miranda. And that simply puts the cart before the horse, because the question that the court was asked to answer was whether the defendants were required to give Miranda. So right there, he's applying the wrong
Tell me
law.
why this did not degenerate very, very quickly into a homicide investigation.
Well, whether it degenerated into a homicide investigation or not is not that much relevant to whether the individuals believed they were in custody.
And the only 2 people who were present at the residence where the child was taken by EMS were Justin and Kara.
Yes, yes.
And it just strikes me as I read the record that very quickly the Leos figured out this is a homicide and here are the 2 suspects.
Well, and I'm not sure that that's an incorrect statement, Your Honor, but the question really is what did they convey to Mr. Garwacki and Ms. O'Connell about what their suspicions were?
And when you look at the tape, they're in Mr. Garwacki's face right from the beginning.
They are concerned about what happened to the child and how it happened to the child. And one of the issues...
But you agree they were right in his face right from the very beginning as an interrogation.
No, I don't think they were in his face. I don't agree with that, Your Honor, because they were very, although they knew some of the injuries that the child had, they were very empathetic and sympathetic, and we understand that children could be a handful. They were not aggressive or coercive. They did not threaten him. They did not show any kind of authority over him as far as, displaying their weapons or any of that. They maintained a level of calm in the interview that allowed Mr. Garwacki to try and explain the cause of the injuries to the child. And that is not the same thing as confronting a person with evidence of their guilt.
Seeing the CD, I mean, it is clear that that fellow did not appear to be in control. I mean, this constant rocking back and forth.
This was an emotional situation.
Yeah.
It was an emotional evening. There's no doubt about it. And what happened to this child caused a great deal of emotion. And certainly, the state is not proposing that being questioned by police officers would not necessarily evoke an emotional response. But that does not mean that you are in custody. The question is, what would a reasonable person believe? Now, Ms. O'Connell called 911 at around 9:30 because this child stopped breathing. So from the get-go, sure, this was a serious situation. And the detectives didn't downplay the seriousness of the situation, but they did not aggressively interview these 2 individuals. They maintained a great deal of calm, a great deal of, reported empathy for these 2 individuals, even though they knew what the victims' injuries were. And as far as that being a confrontation of their guilt, it is not confronting them with evidence of their guilt. It is confronting them with the evidence that they have at the time regarding the child's injuries. When confronting someone with the evidence of their guilt becomes a problem is when you propose to that person, I know where, when, and how you committed these offenses. That is, as in Pitts, the detectives in Pitts came much closer to confronting him with evidence of his guilt, and this court said that an uncorroborated accusation that the person was present at the scene of the crime is not sufficient to raise it to the level of a person being in custody.
What should we make of the comment by the detective who said he didn't read Miranda because he really was hoping they would talk, and in his experience, reading Miranda causes people not to talk?
Yeah, Detective Velez was one of the last witnesses at the hearing, I believe, and his testimony was fairly brief. And yes, he did say that when they first start interviewing witnesses to a crime, they will not put a tape recorder in front of them. They don't ask them to sign papers because it tends to close people off. People who are not even suspects of crimes is what his point was. And he said at that point he did not believe that he or Detective Schramm had a requirement to give these 2 individuals Miranda because he says they weren't under arrest and there was no probable cause for arrest. Now, whether that's a correct statement of the law or his shorthand version of they were not in custody and under interrogation is up for debate, but it's irrelevant really what Detective Valez believed. The question is what a reasonable person would believe. And it is not unreasonable to believe that when you have a 3-year-old child who otherwise has nothing wrong with them and is healthy, dies. I mean, they called 911. They brought law enforcement to them. They brought EMTs to them. That the detectives or anyone in the Sheriff's Department, law enforcement, would want to ask you some questions about what may have happened to this child.
But by the time the interrogation of Mr. Garwicki in specific, I mean, the detectives knew that this was far more than just a healthy 3-year-old boy who just for no reason died.
Absolutely.
They had a lot of information about the nature and extent of some serious injuries.
You know, I don't know if, they certainly had information about the nature and extent of the injuries, yes, because by the time they got to CID, they did have some they knew the child had died, and they had some information about the injuries that were at that point knowable, because there was no autopsy at that point, you know, so there was limited amount of information. And the fact...
They knew this was a homicide by this time.
Well, they may have. I mean, they don't come out and say that, but they do know that there is a serious issue here because we have a 3-year-old child who has died. And they want to get...
With other serious injuries.
Yes.
And this happens in a home where only 2 people are present. And those are the 2 people they take to CID.
Yes, Your Honor. And the state is not proposing that the detectives did not have some suspicion that these 2 individuals may have caused the injuries that resulted in the child's death. But the question is, the court made a determination that they were being interrogated, and the state doesn't necessarily take any issue with that there was an interrogation going on. The real question is whether or not these 2 individuals were in custody, whether they reasonably believed that their freedom of movement was restrained to the extent of an actual arrest. And that is when, if you look at those CDs of these interviews, sure, they are being asked to explain these injuries and what may have happened to the child, but they are not restrained. They are not threatened. Ms. Garwacki is apparently cold, and she gets a blanket or some clothing or something that they had around to cover her legs because she's chilly. She has water. Some of the factual determinations in the order that are erroneous include that the deputy who had driven Ms. O'Connell to the station was left in the break room to quote-unquote monitor the defendants, and that is not what the testimony reveals. The deputy testified that he arrived at the CID and that they walked into the break room. Now, the break room has a door that goes outside to the parking lot and a door that goes into the interview rooms. Those are the doors that need the card to get in. Those are secured areas. But you can walk out into the parking lot. Nobody's going to stop you from walking out into the parking lot. You don't need a card to get out of the break room. They arrive in the break room, and he can't get them into the interview rooms because it's not his division. It's not his department. He doesn't have
a card.
Exactly. He doesn't have a card to get them in there. So they have to wait for the detectives to come out and let them into the secured part of the police station. He testifies that he did some paperwork that he had. He didn't talk to them. He couldn't recall if they were at the same table or separate tables, but Ms. O'Connell was texting at the time, and she was indicating to family members that the police had some questions, and she didn't want to get a lawyer because she wanted to answer the questions, and she didn't think she did anything wrong. So at that point, although the order indicates that they were, quote, in custody from the time they got to CID until the end of the interviews, I don't think that's indicative of someone who thinks that they can't leave if they want to. The trial court's order also talks about, well, they would have had to ask permission to leave because the deputy drove Ms. O'Connell there. Well, Ms. O'Connell had a broken foot. She couldn't drive herself, but she had access to a cell phone. She was texting her parents. She certainly could have said, well, come get me. I've changed my mind. I don't want to talk to the police at this point. She didn't do any of that. The deputy testified that if she wanted either one of them wanted to leave, he probably would have let them leave. He had no basis for keeping them there, except that he was there to drive her home if she needed a ride home, because he's the one who drove her there. Mr. Garwacki was given the opportunity, and this goes to the manner of summons, the first Ramirez factor, was given the opportunity to drive himself if he wanted to. And he opted to take a ride with the detective, and he was put in the back seat of the car because the detective had a bunch of stuff on his front seat. So it's not entirely clear from the testimony, but he was patted down at some point, and I think that was protocol for putting him in the back seat of the car with the detective in the front seat. Ms. O'Connell, on the other hand, was put in the front seat of the deputy's patrol car and driven to CID. There's a little bit of an issue with timing as well here, because the initial phone call, the initial 911 call was at 9:30. And I think the first few deputies arrived very shortly thereafter, because there was a 911 call about a child being down, and deputies will respond in those instances to make sure EMT has access to where they need to be to kind of keep the status quo of what's going on. The order indicates that the deputy kept Ms. O'Connell and Ms. Garwacki separated, and that's not in fact what the testimony reveals. What he said was Ms. O'Connell was in the house, Mr. Garwacki was on the driveway, pretty emotional at that point. Neither one of them tried to get to each other. There was no reason to keep them apart because Mr. Garwacki didn't try to get to Ms. O'Connell. Ms. O'Connell did not try to get to Mr. Garwacki. He was cross-examined on that issue, and in cross-examination he was presented with his deposition testimony, where he did indicate that one of the initial deputy who was there, Kowalski, I believe his name is, asked him to keep them separated. So he then admitted, yeah, I guess if that's what I said in my deposition, he probably did ask me to keep them separated, but he didn't have to, because they didn't try to get near each other. So there's no issue that they restrained their freedom of movement while they were at the house. They were free to walk around wherever they wanted. Mr. Garwacki did not want to go back in that house, and Ms. O'Connell did not want to leave and talk to Mr. Garwacki. So they weren't prevented from going anywhere at that point. So for the first Ramirez factor, that manner of summons, this was not a coercive summons. This was not put you in handcuffs. This was not you must come with us or you'll be arrested. There's nothing in the manner in which they were asked to go to CID that was in any way coercive or restraining to the extent of an arrest. So I don't think that the matter of summons really rises to the level or gives a lot of support to the conclusion that they were in custody. And I want to kind of go back to that initial point that I made, because I think it's important that in that issue, almost the entirety of the issue in the court's order talks about this, again, intentional circumvention of the requirement to give Miranda. You can't decide that somebody is in custody and they should have been given Miranda because they circumvented the requirement to give Miranda. It just factually doesn't make any sense. And legally, the cases that the court relies on talk about the admissibility of post-Miranda statements. When you have a situation where you have an interrogation where the law enforcement know that this person is in custody and they're under interrogation, but I'm going to get the confession out of them first, and then I'm going to give them Miranda midstream and kind of downplay the significance, because I know that even though the pre-Miranda statement's out, the post-Miranda statement's coming in because I gave Miranda. And that's what the Florida Supreme Court in Ross and the United States Supreme Court in Siebert said was improper, because you were downplaying the significance of the Miranda. So we are not going to allow the post-Miranda statement in. That doesn't have anything to do with whether someone's in custody and whether they are required to be read Miranda. Because in those cases, they were in custody and they should have been given Miranda at the outset. So the fact that the court relied on those cases in determining 3 of the 4 Ramirez factors is an application of the wrong law, not just a misapplication of the law, an application of the wrong law. The purpose, place, and manner of the interrogation goes more toward what I think Your Honor was discussing as far as when you watch these CDs. And the state would argue that the manner of the interrogation, although the purpose might have been to obtain incriminating statements or to obtain some information about who did what to this child and when, the manner of the interrogation was very calm. There was no aggression posed either one of these individuals. They were challenged certainly when they gave explanations that did not correlate with the evidence that the detectives had at that moment, but they were never directly accused of causing the child's death, of any sort of coercion. So just presenting someone with evidence of what the police know at that point, absent coercion, doesn't rise to the level of custody. The place obviously was the CID, and the trial court does make some indication in the order that it was significant that they weren't told what that meant, and I don't know really what the significance of that is, because they were asked to come down to the detective's office. I don't think they believed they were going anywhere that was not a police station of some sort. And again, these issues sometimes meld into one another, but the confrontation with evidence of guilt, I think, was something, again, that the trial court misapplied the law there, because the detectives are permitted to challenge a person's explanation about what happened. They are permitted to gather more information in a way that, as long as they are not coercive and as long as they don't indicate to the other person that you're going to be arrested after this. And in, I think it was Ramirez, and I could be incorrect, but in one of the cases that the court relies on, there was an indication, and it might have been Ross now that I'm thinking about it, there was an indication that we have DNA evidence that puts you at the scene of the crime. We know that you are the one who murdered your parents and put the ropes around their neck. It was to the extent that no reasonable person would believe that they were going to walk out of that station without being arrested based on what the police told them they knew. That is not the same as, look, this is what happened, explain it. Can you explain why this child has these injuries? That is not confronting you with the evidence of guilt. That is not saying that you're going to be arrested. In fact, it is allowing them to give a reason that will avoid them being arrested, which is what they tried to do. The defendants in this case tried to avoid the appearance that they were in fact responsible for the child's death in this case. The detectives do press Ms. O'Connell a little bit toward the end, and I think the state makes a recent decision to say at some point that that interview becomes too confrontational, and that they will not allow the evidence beyond that point. And I think it's about an hour into her interview. The trial court also talks about this post-arrest statement and why that is relevant to what they believed pre-arrest. I don't know. And it is another problem with this order because he talks about them being confronted with evidence of their guilt at this post-arrest statement. The state said, we're not introducing that. We have no intention of introducing that evidence to the jury. It was after they were arrested, there was a consent for DNA, and then they do, in that case, do confront them with the pictures of the child that they have, and they do get a little more inquisitive about, can you explain what happened and why didn't you call the doctor and things like that. But that statement's not coming in, and it's completely, in the state's opinion, irrelevant to what they believed prior to.
Becky, you were right at down to 2 minutes. So.
Thank you, Your Honor.
Good morning. May it please the court. I'm Chris Grillo. I represent Carol O'Connell. My co-counsel and I have agreed to divide our time into 10 minutes each, so I will try to keep my comments within the 10 minutes. I would like to address the court about what first began when Miss O'Connell observed the child stop breathing. And unfortunately, no one ever saw the child or observed or reported the child was ever breathing again. So I think the court can clearly infer that the child was deceased, unfortunately, before the paramedics arrived. In any event, Miss O'Connell directed Mr. Garwacki to call 911. He's not breathing, seeking medical attention. Mr. Garwacki made the call at 9:42. Deputy Santiago arrived.
I don't mean to interrupt you, but we have a good handle on the facts here. And okay. I have a question that I really kind of would like to get to, if you don't mind. Based on the facts, as we all know them to be, this tragic incident where this child died, the parents were the only custodians of the child at the time. Based on those facts, would any set of parents believe they were free to leave if they were taken down to the criminal investigative unit of a law enforcement agency, which is a highly secure agency, and were going to be asked questions about what happened that caused the death of the child? Would any parents or ever think that they were free to leave and they were not in custody?
No, sir. And clearly that's the gist of the case. And
explain that hypothetical situation. Sure. And contrast it to what we have here.
Well, what you have here is you have the police arrive, as the court well knows, and they observe Deputy Caban, Deputy Santiago, the other officers all observe the deceased child in the ambulance or being taken to the ambulance. They observe that the child is injured, that has suffered some type of physical trauma, and the child is unresponsive. So the police know from the time they first arrive that not only is the child deceased, but that the child is deceased at the hands of someone. It's a homicide, as the court earlier indicated. At that point, the detectives then, the deputies then begin to interview, for instance, my client. She was interviewed twice. And after the first interview by Deputy Caban is then advised to keep the parties separate. Deputy Caban testified, as the AG said, that he did keep them apart. They were kept apart. There was certainly some element of control there. Then another deputy arrived, Deputy Benjamin. He interviewed O'Connell a second time, told him the same story she told the first time. They're still kept apart. Later on, other detectives arrived. There's a very strong police presence in the house, including Deputy Kowalski, Corporal Wright, and whoever arrived. And then the homicide detective Schramm arrives, and the child abuse investigator Detective Velez arrives. So there's an enormous police presence in the house, as the court is indicating. They have taken over the house. They are going in and out of the house at will. There is, the court in one of its prior cases, Koretsnik, I think is it, I cited in my brief, talked about the home being the most secure place anybody would feel comfortable. And the police have taken that all away from them by constantly going in and out of the house. There's never any real description of any officer ever asking for permission to go into the house, which is...
That's not an issue here. I don't know how that goes to whether there's a
well, I think it is in the sense that it's...
You're arguing that they were beginning to feel in custody even at the house.
Correct, sir. They had no, it's not a Fourth Amendment case, you're right, sir. But I think that with the overwhelming police presence in their home, and they're kept apart, any reasonable person, as the court has inferred, would have felt that they were in trouble, they were going to be in custody. Then my client, Tara O'Connell, is taken down to CID, where you've heard all the testimony about how a secure area it is. The argument has been made that she could have left. There's certainly no indication she ever knew that. There's no indication any reasonable person would have felt they were free to leave. So being taken away from the most secure place where they are to CID, where they have no indication they'll leave, certainly they feel, certainly Ms. O'Connell feels that she is not free to leave, and she has no control of what's happening to her. And the situation escalates after they speak to the co-defendant, where in his statement, he not only implicates himself, but he also implicates Ms. O'Connell in aggravated child abuse. They certainly have probable cause for the arrest based on his statements and the injuries that they've observed and been told about. There's certainly probable cause to arrest for child abuse, neglect of a child, a number of different charges. They have probable cause to arrest both of them before they speak to Ms. O'Connell. So now, I would submit she probably doesn't know that, but you can tell that they know that, and it's obvious from the questioning of Ms. O'Connell by Detective Schramm that she knows she's the target of the investigation. He, at some point in time, tells her, you have to tell me the truth. They confront her with evidence of guilt a number of different times, and who caused the injury. The police made a huge mistake in what they were told, because somehow they learned, or they were advised, that the child had died of or had sustained a skull fracture in the front and the back of the head, something that later, pursuant to the police testimony, was not true. But that was what was driving the police interrogation. So when she's being confronted with evidence that she knows is not true, and she denies it, and they don't let up, they are relentless in questioning her, certainly she feels she's not free to leave. Where would she go? She'd go back to her house where the police have taken over her house. She had nowhere to go, and certainly no reason to believe that she could stop the interrogation at any time. The state has conceded that they were over the top at some point in the interrogation, and I submit to the court they were over the top from the beginning. It was just unfair what they did to her, and certainly they could have advised her of their rights, and they chose not to because they wanted to seek incriminating information, exactly what they're not supposed to do. Now, I disagreed with one of Judge Tharp's conclusions about, pursuant to the Ramirez case, about whether or not they were in custody or what the situation was at the home. He found that they weren't, but I thought his order was otherwise very reasoned. He listened to all the facts. He made judgments about credibility as to the police officers. He determined that they weren't honest about some things, and he made a proper finding, I believe, that they were in custody at the time. And we ask you to affirm Judge Tharp's order. Thank you.
Thank you, Mr. Grillo.
Good morning, and may it please the court. My name is Elisa Smith, and I represent Justin Garwacki. The trial court's decision below was correct. Contrary to opposing counsel's argument, it was well-reasoned, competent substantial evidence supports every factual finding, and also contrary to opposing counsel's argument, those factual findings are supported and reasonable inferences and deductions from those factual findings support the trial judge's conclusions that both Mr. Garwacki and Ms. O'Connell were in custody. They were probably in custody long before they got to CID, or at least the perception was so. As Judge Morris pointed out, there is no reasonable person, let alone a reasonable parent, under these set of circumstances, under the Ramirez guide, under the totality of the circumstances, under the context of this situation, that who would have ever believed that they could have refused the request to go down to the office, as they put it, by the police, could have terminated the interrogation that was ongoing at this secured police facility, or in fact walked away from this highly secured card access facility.
What could the police have done, though, to dispel this reasonable, objective person feeling that they were in custody? Obviously, they didn't want to read a Miranda. You heard why.
Yes.
So where's the middle ground here?
You know, Your Honor, I don't believe there is a middle ground. And I think that part of the problem in this case is that the police, from the very beginning, began to manipulate the situation and exploit the reasonable person and the reasonable parent. As soon as they arrived at the scene at 9:42, this was a highly police-dominated environment. Or to quote the Bannister cases relied upon by opposing counsel, this was a whirlwind of accusatory activity. We had police officers arriving, the son leaves in the ambulance, which to this day boggles my mind, that a reasonable father felt like he could not ask to go to the hospital with his own son. More police officers come.
I'm not sure that tells me anything, because if his condition on the driveway was anything like what was in the CDs, he was just absolutely distraught, incapable
Absolutely distraught, yes. And detectives arrived, and then at 10 o'clock, these detectives know that JT died. And this is why I think there is no common ground. They knew at 10 o'clock, almost 15 minutes after they left that scene, that this child had died. They waited 2 hours before they told my client that his son was dead. 2 hours he sat in that driveway by himself, rocking back and forth, crying. There's uncontroverted evidence that my client was destroyed by this situation. They waited, and they waited till midnight. And then they went up to my client and they said, "Your son died. Can we ask you questions?" Honestly, a reasonable person in that situation was even more devastated than when his son was taken away in an ambulance 2 hours before. Then when they couldn't get any information from him because he was further distraught emotionally, then they said, "Would you be willing to come down?" I can't even imagine what his answer was. We saw what his answer was on the CID tape when 3 minutes in they say, "You're here voluntarily, right?" "Uh-huh." "Yes." As he's rocking back and forth. From the moment these police arrived, they exploited the reasonable person's response. That's why there's no common ground. And they took them away. He separated from his girlfriend who's in the home. He separated from his other daughter. He goes down to the police station. And as he's in this police station where they're locking them in, they're sitting in a break room, there's no testimony that these two people ever communicate. And I'm sorry, I don't find it reasonable that the prosecutor suggests that this officer just happens to be in the break room, sitting there doing work. He's monitoring their activity, and any reasonable person in that situation would have perceived that they were being monitored, one taken out, one left, and so forth and so on. And obviously you've watched the tape. As soon as they're in that room, the two seasoned, experienced detectives, one a child abuse detective and the other a homicide detective, sit situationally in this very small room with their backs to the door and my client in front of them. So the only way he could leave that room is through those two police officers. No reasonable person. This court's cases the Florida Supreme Court cases suggest that no reasonable person, under these contextual totality of the circumstances, would have felt free to walk out of this crime investigation department or terminated that interrogation. What's also interesting and very similar, nuanced at least, with the Ross decision, my client, sitting in that room, rocking back and forth and crying when they left the room, asked to smoke a cigarette. And they said no. There's no smoking in this building. They didn't say you can go outside to smoke that cigarette. They didn't say, sure, we'll bring you somewhere. They just said, no, there's no smoking in this building. He felt like he needed to ask permission to smoke a cigarette. Very similar to in Ross, where he said he wanted to go outside to smoke a cigarette, and they said, no, you could smoke here. The trial judge came to the right conclusion. There's competent, substantial evidence to support. I'm not sure I understand the opposing counsel's argument that the trial judge employed the wrong standard. This is a very well-written order. I wish all of the orders I got were this well done. He does a complete background of what happened leading up to the 4 factors. He does evaluate whether they were informed, and he merges the 1st and 4th factors of Ramirez in his order, but he finds that the officers lack credibility, that they really weren't truly informing. And that deliberate delay, again, in Ross, is a factor, a legitimate factor, in evaluating a reasonable person. In this particular case, in my case, a reasonable father would have felt free. And finally, and probably most importantly, the 3rd Ramirez factor of confronting these individuals, particularly my client. I haven't watched the other video. He was absolutely confronted by evidence, far more than in Pitts. In Pitts, this court said that, yes, precedent is a guide, but it's probably less important in these highly unique factual situations. In this highly factual and unique situation, they allowed my client to talk, and then these seasoned officers said, and they threw down their pad and said, we don't believe you. We know, we've investigated these cases. This is not accidental. These injuries that we know about, and they go through and detail these injuries. This is very specific, unlike in the Pitts case, where it was general allegations of, we found you pawned some of these items, and TJ says you killed the guys. That's not what happened here. What happened here was they went through methodically all of the injuries on this little boy and said these are not accidental. They showed them cell phone pictures of the little boy. This was extraordinarily confrontational. This was confronting this individual with suggestions that he was guilty of a crime, whether it be homicide, aggravated child abuse, or failure to protect his son. No reasonable person confronted with that kind of evidence would have ever felt free to leave. Judge Stark reached the right conclusion. We ask that you affirm the lower court ruling. Thank you.
Thank you. Thank you.
Mr. Garwacki never asked to go to the hospital with his child. He was not prevented from going to the hospital with the child. He didn't ask to go. There's no evidence that he ever said, I want to go with my child in the ambulance to the hospital, and he was prevented from doing so. There is simply no evidence to support that. 35 minutes into Mr. Garwacki's interview, he says, I don't feel defensive at all. This is a man who's being coerced into making a statement. Is it emotional? Sure. But he says, I don't feel defensive at all. He's trying to explain what happened to the child. The detectives are very calm. Whether a reasonable person would have thought at the outset that, boy, I think these police aren't going to let me leave, what the detectives exhibited during those interviews was a very calm, a very empathetic, a very sympathetic manner with talking about what happened to these children. He never said, none of the detectives ever said, this is an accident and you did this. What they said is, look, children are a handful. Maybe the discipline got out of hand. Tell us. And if you look at those interviews, you will see that the defendants are the ones who are doing most of the talking. There is long stretches of time where the detectives don't ask them anything. They are there and they want to explain away this child's injuries. They are there voluntarily. They were not coerced. There is nothing about this situation that would cause a reasonable person to believe that they could not leave. Mr. Garwacki wants to smoke a cigarette, and he's told, hey, pal, sorry, there's no smoking in this facility. As a matter of fact, they won't even let us smoke outside, which is true. They're not allowed to smoke outside of the facility either. That's not the detective's fault. That doesn't mean you're in custody. It means that's a rule that we have here at CID, that you're not allowed to smoke cigarettes, sorry. But he was allowed to smoke a cigarette in the car on the way. He wasn't prevented from doing that. There was nothing that these officers did that would rise to the level to lead a reasonable person to believe that they were in custody and they were not free to leave. And in fact, as we know, they did leave and they went home.
Did he ask to smoke a cigarette, or did he say he was going to go smoke a cigarette?
I think he asked to smoke a cigarette. They were leaving the interview and he said, hey, can I smoke a cigarette in here? And the detective said, no, sorry, no smoking in here. And then I think he even said, can I go outside? And then the detective said, well, you know what? They don't even let us smoke outside. And that's just a statement of fact. That's not coercion. And that is at the very end of his interview. So the state would ask that this court reverse the order granting the motions to suppress.
Thank you, Ms. Becky. Thank you all. Court will be in recess for 15 minutes.